Most people think they don't have an estate plan because they haven't formally done a will or a trust. But the reality is, you actually do have an estate plan, even if you haven't formally done one on your own. It's just that the state of California has written it for you. In other words, there are default rules that kick in when someone dies without doing any estate planning. You probably are not going to like the default rules, which is why we do estate planning, so that you can override the default rules for your family and assets, and ultimately so that you can make these important decisions for yourself instead of letting California make it for you.
So, dying without a will or a trust is what we call dying intestate. And this may be the situation that many of you are in now. This is the doing nothing scenario, and it means you'll end up with California's default plan. So let's talk about what the default plan is. In California, if you die without a will, assets are going to be distributed according to generic law. This means your stuff could go to people you don't necessarily want it to. Children inherit at 18 years old, and they could blow it immediately or lose it later on due to divorce. A spouse could remarry and leave everything to a new spouse and their kids. Ultimately, though, a judge will decide who gets what, how it all happens, and most importantly, probate court is guaranteed. Now, if you're okay with this default plan as we've laid it out, you don't need to do any estate planning. But we've yet to meet someone who actually wants anything on this list to happen.
So what is probate court anyway? Now, I'm not going to harp on this topic and try to scare people, because most people know by now that probate is a gigantic waste of time, money, and energy for your family. But let's cover it really quick at a high level. First, it's important to know that whether you have no plan at all or you have a will-based plan, your estate is going to go through probate court. A will by itself does not save your family from this headache. The main purpose of probate is to settle the affairs of a deceased person. So that means that your family is clearing creditors, determining rightful heirs, and changing title on the property that you own from you to your family after death. Your family will need to create a complete list of your assets, and then a probate appraiser will provide a formal valuation of each and every asset. If anyone decides that they want to contest the will or they demand an heirship determination, all of those disputes get settled in probate court, and then the assets are distributed to the rightful heirs or beneficiaries. This entire process is overseen by a judge, and you need the court's permission to do anything. Almost certainly, your family will have to hire a lawyer because it's a complex process. On average in California, probate will usually take about 1 to 2 years, and the cost is based on a percentage of the total value of your assets. So when a house is involved, a $20,000 to $30,000 probate bill is pretty typical, but the fees can easily get into the $50,000 plus range. And it's much, much more expensive and lengthy, of course, if people are fighting or if you own properties in multiple states and your family has to go to probate court in each state. So while your family's court experience probably won't be as traumatizing as Colonel Jessup's, it won't be pleasant either, because court is just never a very fun process.